So after your work injury or after your car accident, and after a year or two of treatment, maybe including surgery, maybe even more than one surgery, one day your doctor mentions that on the next visit, he or she's likely to refer you to something called a functional capacity exam, often referred to as an FCE. And also after that, probably see you back maybe once more and then release you from care. You're still hurting. And after hearing this, you're quite concerned. I mean, is this the end of my workers' comp case? Are my benefits going to be cut off? What does this FCE thing mean? So I'm Joe Miller, as many of you know, and workers' compensation attorney and personal injury attorney in both Virginia and North Carolina. And today I want to talk about this whole concept of a functional capacity exam, or FCE, what it is, what role does it play in your workers' compensation case, which we'll talk about first, or your personal injury case, or your car accident case. At some point in your case, your doctor is going to deem you to have reached what's called maximum medical improvement, or MMI. That's the point at which, in your doctor's opinion, there really is nothing else medically that can be done to improve your injuries insofar as your physical capabilities are concerned. So now way back in the day, and I'm giving away my age here, if your doctor believed that you had permanent physical limitations, he or she would then go ahead and provide a work note that set forth your permanent physical limitations on that work note. And in the worst cases, it would say incapable of any work on a permanent basis. Or for example, in somewhat less severe cases, it might say permanent lifting of no more than 50 pounds, or another example, permanent restrictions of no ladder climbing or walking on uneven ground. And sometimes the doctor would also, just on his own, without anything else, just give an opinion on a rating for a certain body part, meaning percentage rating. He would say 20% permanent impairment, for instance, to the left lower extremity if you had an injury to your, let's say your ankle or your leg. And there are still a few, intrepid doctors out there here and there who will go ahead and do that without the benefit of what we're going to talk about in a minute, which is this, what we've been discussing, which is this functional capacity exam, or FCE. For better or for worse, that is not how it's done today. We will qualify that a little bit. The same thing, it does end up happening. You do end up with permanent restrictions, and the doctor's going to issue those restrictions and possibly a rating as well, both of which we're going to discuss. But today, there's this other step now that's been inserted into the process, which is viewed, again, rightly or wrongly, as presenting a more solid medical and scientific basis upon which the doctor can rely when he's going to give this opinion about your permanent restrictions and or your rating. And that's this thing that we're going to talk about, which is a functional capacity exam, or FCE. Essentially, it's a very long examination or series of tests at a physical therapy facility by a specially qualified therapist to determine what you can and cannot do insofar as your injuries are concerned. And that's pretty much it. It typically lasts about 4 hours. And yes, you will be hurting afterwards and probably during the testing as well. And that's normal because basically it's designed to determine if you're giving maximum effort or possibly, faking how bad you're hurt. If you're treating with an orthopedic, the orthopedic is going to simply refer you to their in-house facility. Sometime after you're put through your paces by the physical therapist at the FCE, and you go through this testing, usually within a few days after it's done, the therapist is going to go ahead and write up a very detailed report, usually 10 to 20 pages, much of it generated by computer, as to all the measurements that were taken, all the things that you could do, your range of motion, your lifting capability, your ability to climb stairs, ladders, stoop, bend, crawl, all of it. Then that report's going to be sent to your doctor, and your doctor's going to sign off on it. Usually there's a space provided for the doctor to sign off on the report. And when you return to your doctor, he or she will then typically issue a work note. Oftentimes it just says permanent limitations per the FCE. Every now and then you'll see a doctor will go in and make some corrections. Maybe they think that the FCE is not an accurate representation. They might think, well, I don't think he can do this for this long. Let's cut that back. And they'll actually go in and make some corrections. That's rare, but I have seen some doctors do it. Typically, they're just going to rely on the findings of the FCE. Why do we need to know your permanent restrictions once you've reached maximum medical improvement? What is so important about this? Why does it matter? And I've discussed this in other videos, but let's get into the workers' comp aspect first. Assuming you're under an award in Virginia or an accepted claim in North Carolina, you're typically going to be entitled to up to 500 weeks of benefits. Okay, that's the weekly check you receive for 2/3 of your average weekly wage, otherwise known as temporary total disability. Let's say you've been on light duty, okay, and you haven't been able to return to work, and you're getting your checks, and the FCE has done it. It says you are capable of full return to your pre-injury level of work, otherwise known as full duty. Okay, now even if you've been terminated from your old job in the one you had before the accident, okay, at this point, even if your employer has not held your position open, whatever, your weekly benefits at that point, once the doctor signs off on that FCE that says you can return to full duty, your benefits are over. They're going to stop. Okay, this is because, insofar as the law is concerned, you have no more impediments to return to work. You're full duty, and you're therefore not entitled to any additional weekly benefits unless you receive a permanency rating. Now, if you do receive a percentage rating, okay, you may be entitled to some additional weekly benefits depending on your rating. But if you return to full duty, the rating might be kind of small. Now, the details of what a permanency rating is on a specific body part, I have a video that gets into pretty good detail, I think, on that issue. I invite you to look up my video. It's on the YouTube channel or on our website about permanency ratings. The main thing to look at insofar as the FCE is concerned, and the main thing we need to know is what your permanent work capabilities are, okay? Because here's the way this works. If the FCE report and your doctor say you're not released to full duty, okay, or full pre-injury employment, and you're under an award or accepted claim, and the FCE says you have permanent physical restrictions that prevent your return to your pre-injury job, then the workers' comp carrier, especially meaning the workers' comp insurance company, especially in Virginia, is obligated to continue to pay you your weekly benefits for potentially the remainder of the 500 weeks. So that is, unless and until the comp carrier can either have you come back to alternate employment at your old job, meaning within your physical restrictions, or find you another job within your restrictions at another employer. They do this through something called vocational rehabilitation, or voke rehab for short. And if they can't do one of those two things, either of those two things, then they have to keep paying you those checks every week for up to the end of the 500 weeks since the payment started. Okay, so here's what that means for your case. If the FCE says you can't return to your pre-injury job, right, then you potentially have a huge bargaining chip at that point with the workers' comp insurance company to try and settle your case. Because, as we just said, if you're unable to return to your job, then the workers' comp insurance company is going to be on the hook. Let's say the FCE says you're going to be restricted permanently to sedentary duty, meaning a sit-down job. And let's say your accident, so far you've been paid 70 weeks, okay, of benefits, okay? At the time you officially receive your permanent restrictions from your doctor, and he or she signs off on the FCE. So let's say your comp or TTD rate of pay for your checks is $700 a week. That means you have 430 weeks of benefits left, potentially under your award at $700 a week, meaning the carrier is potentially on the hook for another $301,000. Does that mean that they're going to be looking to settle your case for, that part of your case for $301,000? No, that would not be a settlement, right? If they just paid you the whole amount. But in many circumstances, I would say even most of the time, depending on your pre-injury job and your transferable skills, the workers' comp insurance company is going to be interested in offering you some portion of those weeks, plus a portion of a reasonable estimate of your potential future work injury-related medical bills that they're going to have to pay in a lump sum to try and close out your claim. That is the only avenue, in fact, available to you to receive a lump sum at any time in your workers' comp claim, unless you go to a hearing and you have back benefit, a denied claim, and they owe you a bunch of back benefits or something. But there's no way other than that. You can't go to a commissioner and say, I want to be paid that $301,000 now. Unless you settle, it's going to come only drip, drip, drip to $700 a week for the next 430 weeks in our example. The workers' comp insurance company is going to try to reduce or eliminate their obligation to pay that weekly obligation in our example, let's say, of $700 a week by forcing you into voke rehab, okay, and into a job you don't want. But many times those efforts fail, and then they want to settle it. And in fact, and I would just, since we're mentioning voc rehab so much, I would invite you also to watch that video. I have a video on specifically on vocational rehabilitation in Virginia, North Carolina. Also, I'd invite you to watch my video on workers' comp demands, because if I'm your attorney in your comp case, the moment when you get those permanent restrictions from your doctor and you're at MMI and you get those restrictions and that's when we're going to discuss issuing a demand in your claim to try to settle the case. A demand is basically a letter I send to the other side, to the insurance company, and if there's a defense attorney, to the defense attorney to say, this is how much we want to get paid to resolve the claim. Up until now, we've been talking about workers' comp cases. So what about personal injury? And by that, I mean like a car accident case, okay? So these FCEs can play a pretty critical role in those as well, for similar reasons. However, here's the key difference. In a car accident case, if the FCE says you can't return to your job, right, because of your injuries, we're not under an award now. There's no award. We're not a workers' comp case. We just it's basically an opinion that you can't go back to your old job. What we're looking for in a PI case, or when I say PI, I mean a car accident case, basically, is the amount of damages that you can prove to a jury, which is of course limited by the amount of automobile insurance that everybody has. In other words, how much you had on your car and how much the other party had on their car. If the amount of coverage available warrants it, what many lawyers who represent folks injured in car accidents do is they will actually hire their own voc rehab person to give an opinion. Why? Because if you can't go back to your pre-injury job, let's say, okay, then the question then becomes, what is the impact of those limitations on your job prospects for the future? What is the likelihood that you're going to be able to obtain a job within your permanent physical restrictions? If you do obtain a job, how much are you likely to make? If you were making $1,000 before the accident and now you're limited with your physical restrictions, if we can prove that, now you may be able to get a job, but it's only going to earn you $400 a week, this is a good opportunity for the voc rehab person to come in and prove those things. A good voc rehab counselor is going to be able to provide the jury with an opinion on these matters. And if the impact is severe on your future earning capacity, then the attorney may also hire what's called an economist. That person is going to take the opinions of the voc rehab counselor, which includes specific calculations, and converts those opinions basically into dollar figures so that the jury can understand, say, okay, this is what this guy is going to lose because of his physical limitations. And that's important evidence in your claim. In other words, the voc rehab counselor is going to comment on the likelihood of you being able to obtain another job, given your permanent restrictions. And if you can get another job, how much you're likely to earn in the new occupation. And that's going to depend on many factors that we discussed before, including your age, your education, your skill level. If you want to get into, really drill down into the specifics of this, I want to invite you to look at our book, the book I wrote, which you can find on the website, which is called How Much Is My Case Worth? And I really get into a lot of detail in the book about all the factors that go into how you value an auto accident case. So to finish up, let's go through what you are typically going to see. What are we looking at in an FCE report? The main thing my eyes look for when I'm looking at it, first, is the opinion of the therapist as to whether my client's going to be able to return to his or her pre-injury work, okay? Because as we discussed before, that's really critical. If the answer is yes, well, that's great news that you can go back to work. It's bad news for the case because, as we discussed, now you have no loss of earning capacity, your damages. If it's a workers' comp case, there goes the rest of your weekly benefits out the window. Assuming the report, though, says, no, you can't go back to your job, then we're going to look at the level of physical work that you're going to be restricted to, okay, per the FCE. So this falls on a spectrum. The lowest or least capable is known as sedentary work. We discussed that a little bit before, being like a sit-down job. And the highest is going to be what's called very heavy work. And these have been established for quite some time, the spectrum, by the U.S. Department of Labor. And it can be found in many places, but they're essentially in relation to lifting restrictions, and they're as follows. Sedentary is 10 pounds occasionally. Light is 20 pounds occasionally, 10 pounds frequently. Medium is up to 50 pounds occasionally, up to 25 pounds frequently, and 10 pounds constantly. Heavy work is up to 100 pounds occasionally, 50 pounds frequently, and 20 pounds constantly. Very heavy is over 100 pounds occasionally, more than 50 pounds frequently, and more than 20 pounds constantly. Occasionally is up to a third or 2 hours, 40 minutes out of an 8-hour day. Frequently means 1/3 to 2/3 of the day, or up to 5 hours, 20 minutes. And constantly means it exceeds 2/3 of an 8-hour day. There's also something you want to look at on these reports, which is usually called the physical capabilities page. That page is usually going to consist of a very detailed chart that is going to list each and every activity you were tested on and the extent you can do it, and whether that capability is consistent or inconsistent with the requirements of your pre-injury job. In other words, can you do it, can you not do it? For instance, if you have a severe ankle or a leg injury, it may say avoid climbing ladders, or it may say avoid climbing stairs. If you have a multi-level back fusion, it may say avoid bending, stooping, squatting, or crawling. Sometimes it will have other limitations listed such as driving or walking. I hope I've given you some idea what to expect and what an FCE is about and why it's important for your workers' compensation or auto case. If you or a loved one have been in an auto accident or in Virginia or North Carolina, or suffered a work injury at North Carolina, you have any questions about FCEs or any other question about your case, please don't hesitate to give us a call, or you can contact us via our special form on the website. We're friendly, we don't bite, I promise. In the meantime, please have a blessed day. Joe Miller out.